Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about national security. Cases that should have gone to the Supreme Court of Canada, but didn't. In a trial for alleged conspiracy to commit terrorism offenses, the accused argued that he was pretending to go along with the conspiratorial plot on the basis of the fact that he wanted to dupe the people who were doing this out of money. As a result of that, he testified that this was his purpose, but his testimony was disbelieved, and he was found guilty of a number of the offenses for which he was charged. One issue that arose in the context of the trial, however, was an affidavit that was produced by a national security agency in Canada containing information related to the investigation of this as a terrorism-related offense. Significant portions of that affidavit were redacted in the disclosure and were not admitted in trial as a result. The accused argued that they should have full disclosure of all of the evidence, and the government claimed national security privilege over the evidence. And this case raises very important issues. Rarely do we see opportunities for the Supreme Court of Canada to clarify national security privilege. And this case is so much more important than many others where this has come up in the context maybe of contractual dealings or of civil relationships, because this was a criminal charge where the accused was ultimately sentenced to life in prison, the most significant sanction you can face in Canadian law. When your innocence is at stake and when you are facing the highest possible consequence you can get for a very serious charge, isn't it more important to allow access to the evidence than to protect national security in some way? And aren't there safeguards that could be put in place to allow use of the evidence for the purposes of responding to the charges without making it public? There are things like sealing orders, there are exclusion orders. All of these things could be considered. And it would be nice to see the Supreme Court of Canada give a more thorough consideration to national security privilege when it is claimed in the context of criminal proceedings with serious outcomes. Unfortunately, it's going to take another case with a national security component before the Supreme Court of Canada has the opportunity to hear this. And those cases are few and far between, but they are significant. And the Supreme Court of Canada should have recognized this opportunity, especially as there's a lot of litigation that's happening in the federal courts, in the lower court levels, currently related to issues around national security. Unfortunately, it won't be long before the Supreme Court of Canada is asked to hear a case like this, and hopefully the next time they hear a case and they provide some guidance that may also impact in criminal cases where serious sanctions are possible. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.